Good afternoon, everybody. Thank you once again for joining us. I'm Brian Tully from Tully Law Group, and today is our Wednesday webinar. Today we'll be talking about trusts. What are they and why do I need one? Okay, it's going to be a good topic. We get these questions every single day of the week. But like always, I'm not going to begin for a couple minutes. Let people log on. All right, so I'll be right back. Okay, everybody, we're going to get started. I want to be respectful of your time. I hope some of you were able to join us last Wednesday for our Senior Advocacy Forum. We had some guests talking about health and wellness and financial organization for seniors as we enter into the new year, that resolution type of stuff. So it was a nice discussion. It's on our website if you want to check out the recording of it. TullyElderlaw.com and under the video tab, and you can see that from last week as well as all of our prior webinars that we've been doing for nearly 3 years at this point. But again, thank you for joining me. Again, Brian Tully, the founder and now managing partner of Tully Law Group. If you've been following our social media, there's been a lot going on for us. Expanded and opened up our office out in Riverhead. And then we brought in 2 new partners and promoted Amy from within. Amy's been with me for 10 years. So I now have 3 partners here as we build and grow and continue to help Long Island with planning, with protection, with helping folks really have peace of mind as they're aging, as we help with them as well as their families. Now, what do we help them with? Well, that's really what we're going to talk about today, or at least a piece of it. And we're going to talk about trusts, okay? Now, as I get started here, and I'm probably a minute late in saying it, I would like somebody, please, to make sure that you can hear me and see my screen. All right, I'm sharing my screen, so all 3 things: hear, see me, and see my screen. Great, thank you, Steve. All right, so again, trusts, what are they and why do I need one? Right off the bat, should everybody have a trust? Not everybody, but should most people have trusts? Sure. There's enough reason for the vast majority of us to have a trust in place. The question is, though, which one? So we'll get into that a little bit today. If you have questions, please feel free to just put it into the Q&A box or the chat box, and I'll be happy to answer them towards the end. All right, so let's get going. So first and foremost, part 1, what is a trust? Now, when we talk with people, the word trust, the concept of a trust can be intimidating. Some clients would actually reply going, no, I don't have that kind of money. But the reality is a trust is a very simple concept, and it's been around for over 1,000 years. It's the concept where you are going to trust somebody with your assets to manage them within a certain way. So the people that you have involved are very important, all right? We're talking spouses, we're talking children, partners, families, siblings. And again, not a very complicated concept, but and also should be utilized by a lot of people. But specifically, a trust, in order to be done properly and most practically, should be a written agreement. And again, this written agreement is going to create an entity, kind of like a corporation. It's transparent, it's invisible, but an alter ego, if you will. But it is an agreement that will create an entity. And it really just governs three different aspects, all right? It will govern the management of the property while you are alive and well. It'll govern and manage the property if you are alive but not healthy, if you're ill, disabled, receiving long-term care. And then ultimately, and I say this so that it's easily understood, it kind of acts like a will without the court proceeding called probate. So it'll deal with your assets, manage your assets while you're alive and well, while you're alive but not as well, and then once you ultimately pass on. So in sum, a trust will handle the management of your property while you're alive and then handle the distribution of the property that's inside after you're gone, okay? A written document has to be signed not only by the person creating the trust, but also by at least one of the trustees to create this entity. It does usually continue on after death so that it can be administered and wrapped up. And ultimately, it does need to be closed. We've sat with clients that have had trusts for decades that the grandfather set up, and all the terms had been fulfilled, yet they never officially closed it. A word to the wise, and we're not really getting into it today, but a person serving as a trustee should not be distributing money to the ultimate beneficiaries of the trust unless there is a certain agreement signed called a receipt and a release. Okay. And then that's what's ultimately going to close the trust. When the beneficiary receives the money, the trustee is released from their duties so they can close that chapter, knowing that they're not going to get sued, and that you're able to ultimately close the trust on the books. Okay. Now, there are four parts to a trust. All right. What we're looking at is, and if you know me, if you've met with me before, I try to simplify. We all try to simplify things as much as possible here. So the first part to a trust, the first requirement of a trust is you need to have a grantor. That's the person creating the trust, what we call the grantor, the person granting the trust. Other attorneys, other states can use the phrase settlor, or they can use what's called trust maker. I obviously don't prefer either of those. I prefer the phrase grantor because they're granting it. Now, again, they're the ones setting it up. In some circumstances, that grantor is also the trustee. In other circumstances, that grantor is not the trustee. And what's the trustee? The trustee is the manager. Okay, the trustee is the one that's charged with doing with what the trust says, being responsible for the management, being responsible for distributions. They are a fiduciary, so they really have to do what the document calls for. They have to put the beneficiary's interests above their own, which brings me to the third part of a trust, and that's the actual beneficiary themselves. There can be several different types of beneficiaries. You can have a lifetime beneficiary that's entitled to certain things. You could have what we'll call a death beneficiary, which means they inherit after the person or grantor perhaps has passed on. You can also have what's called an income beneficiary, or even a principal beneficiary. So there's different interests as this gets built, and a lot of that has to do with what's the purpose of the trust, what are we trying to accomplish, okay? Now the fourth part of a trust is going to be the assets that go inside, all right? Again, if you've met with us before, the legal phrase is called the principal, all right? The principal are the assets inside the trust. Other attorneys, other states use the word corpus, C-O-R-P-U-S, the body of the trust, okay? So if you have a trust without a beneficiary, it's not a trust. If you have a trust without something owned by it, it's not a trust. And a little side note there, if you've ever seen a trust before, there's the last page is typically called a Schedule A. That's an informal listing of what's inside the trust. And usually it'll start with $10. Okay. That's just a symbolic way of saying there's money in here being transferred from the grantor to the trustee, just in case there really isn't an account transferred in just yet, or perhaps a home transferred in just yet. So that symbolic $10 covers that last requirement. All right. And again, any questions about this, put it into the Q&A box or the chat box, and I'll get to it when we're done. Now, two big types of trusts. All right. Trusts are going to fall into two categories. The first one is what's called a lifetime trust, or what's called an inter vivos trust. All right. An inter vivos trust is one that is created during the lifetime of the grantor. So lifetime trusts, inter vivos trusts, if you've seen the phrase living trust while the person's living, those all mean the same type of lifetime trusts. Now, the alternative to that, the opposite of that, is what's called the testamentary trust. All right. That's not one that is established or funded during the grantor's life. Rather, it is as we get to this, it is within their last will and testament. Okay. So again, living trust, lifetime trust, inter vivos trust, set up, active, and funded during my lifetime, for example, as grantor, versus a testamentary trust, which is one that is set up in my will after I pass away and requires probate in order for it to be given life and funded. Okay. If you have a simple will, or let's just call it a will, if you have a will in place, there should be testamentary trusts built in there already for example, if there's certain contingencies. If you have a minor child or grandchild inheriting, there should be a testamentary trust built into your will as a contingency. If there is a disabled child or grandchild, there should be what's called an S&T as a testamentary S&T built into your will. S&T stands for Supplemental Needs Trust. Every trust we do, every will we do, will have a contingent trust based on age and a contingent trust based on health. Contingent means it doesn't happen unless that contingency is met. For example, if we have a will leaving all the assets to two children, 40 and 35 years of age, if God forbid the 40-year-old predeceases the parent, that 50% inheritance, first contingency, goes down to the grandchildren. Second contingency built in is how old are those grandchildren? Are they over 25, for example? Any age that the client wants to pick. If they're over 25, they get the money. If they're under 25, then we're concerned as to how they're going to spend it. So we have the money held by the sibling, perhaps, until they're older. Money can be spent for health reasons, education reasons, or what's called maintenance and support. Now, if there's no grandchildren, then the contingency would kick in that the predeceased half would go to the surviving child. All right. Now, if we have assets in that scenario going to a grandchild, and perhaps that grandchild's disabled, we need to have language in there to shelter that inheritance. Because if it's a significant enough of a disability, that grandchild might be on government benefits. And if they inherit from a grandparent, they're getting kicked off of those government benefits. Perhaps the state is getting paid back. And now what? Right? So every will that's out there, and believe me, I sit with clients where we're looking at a 3-page will. There is no contingencies built in there at all. And that is dangerous. That is treading on thin ice. Contingencies need to be built in. Age, health, beneficiary issues. Moving on, another type of testamentary trust for certain folks is what we could call a marital trust. All right. And all of these trusts, as I'm sharing, can also be built into those inter vivos or living trusts, lifetime trusts as well. but these are just examples of some testamentary trusts, okay? And when I say a marital trust, what we're looking at is generally an estate tax concern, okay? We'll talk about that a little bit later as we move forward. So if those are the testamentary trust options, again, in your will and requires probate, which is a whole other thing we'll get into shortly, what are the types of lifetime trusts? All right. So again, the idea of trusts breaks down into inter vivos or living or lifetime trusts and testamentary trusts. Now, lifetime trusts then break down into two further types of trusts. Okay. And this is what we're going to spend a lot of the time on today. The first type of trust that we do very often and people hear about talking to neighbors, friends, is what's called a revocable trust. Okay. So if revocable is the first type of lifetime trust, the second type of trust is going to be an irrevocable trust. Okay. Now, all for different purposes and different reasons that we'll get into. If you have questions, just put it in the box and we'll deal with it later. Now, why would somebody go revocable or irrevocable? All right. And you might think I'm going fast here, but I'm doing what I can to share in the time that we have allotted. If you have questions about revocable trusts, irrevocable trusts, again, we've been doing these webinars for 3 years. Go to our website, tullyelderlaw.com, and go through our library of webinars. There are webinars in there on revocable trusts as well as on irrevocable trusts, and then you get into the nitty gritty. All right. I am going to be covering some details today, so stand by for that. But generally speaking, why would I do revocable or why would I do irrevocable? Well, there's a reason that somebody would choose a revocable, and there's a purpose that somebody would choose irrevocable. There's two main purposes. The first one is if a client comes in or if they accept our recommendation that we need to avoid the court proceeding called probate, we're going to be looking at a revocable trust. Another major reason, significant reason to do an irrevocable trust is what's called asset protection. We'll talk about that today as well. Now, if the revocable trust is all about avoiding probate, the irrevocable trust is all about asset protection. Okay. Now, what that means also is because it's a trust, an irrevocable trust will in fact avoid probate. So you get two benefits with the irrevocable trust. However, the revocable trust, because of the way it's built by its own nature being revocable, it doesn't provide any asset protection. Okay. An irrevocable trust for asset protection purposes has to be built a very specific way, contain specific language, and all of the people involved have to follow that language, all right, in order to gain that asset protection. Again, word to the wise, revocable trusts do not, in fact, protect from creditors. Revocable trusts do not protect against nursing homes. If we're looking for asset protection, the two green marks on the bottom are going to be the irrevocable for probate avoidance and for asset protection. Okay, so that is my introduction as to what a trust is. Different types for different purposes, written agreements, the different parties that are involved. Again, questions, just put it in the chat box and I'll answer later. Now, the second part of why we're here is to talk about why do I need one, okay? And I hope you like our new graphics here. A lot of this is based on my old templates of webinars, but I was able, my marketing team gratefully put together some nicer slides, which this is one of them. So here you go. Next webinar will have all of the nicer slides, I promise. Actually, I'm not going to promise because it's hard to redo these things, but that you'll see them eventually. Why do I need a trust? Well, there are several reasons that people should have trusts. Again, revocable or irrevocable, that's to be determined. But there's 4 primary reasons that I will right off the bat, my attorneys will right off the bat say, listen, we should be looking at a trust here, okay? First reason is long-term care. As we get older, we might need care, and the concern is how do we pay for it? Second reason to avoid, or forgive me, second reason to have a trust is to avoid probate. I've said it several times already. We'll get into the reasons of why shortly. A third reason to have a trust is because of your beneficiaries. Who's inheriting your money? Are they going through something? And I'll have those bullet points for you in a couple of slides. But we have to be mindful of who's ultimately inheriting. It's not just about you as the client. Where is this money going and how is it getting there? When is it getting there? How can they use the inheritance? So all of that goes into a trust so that you're properly planned for. And finally, for our purposes today, if we're dealing with what I'll call a taxable estate, right, we're going to get hit with either New York estate taxes or federal estate taxes, then for a whole host of reasons, we're looking at trusts, perhaps revocable and irrevocable. Okay, so we're going to get into this at this point and talk about long-term care, talk about probate, some beneficiary issues, and then touch upon estate taxes. Okay, now a little bit more about long-term care. Now, this is our bread and butter. Elder care and estate planning, that is what we do every single day. I've been doing it for 25 years. There's 7 attorneys here, including myself. We have a staff of up to, I think it's 19, 20 people at this point. And this is what we do, elder care and estate planning. So long-term care is a big chunk of our services every single day. And we do it differently and, dare I say, better than a lot of folks out there, because we focus on the care issues. We're not just about the trusts. We're not just about, oh, I need Medicaid. It's not only about that. That's crucial, but it's not just about that. We have care coordinators on staff. Both Raina and Deanna, fantastic, experienced elder care coordinators that will advocate for the family during these long-term care considerations, all right? So again, if you need more information on it, our webinars going back a couple of years talk about long-term care, talk about elder care, talk about Medicaid at length. You want to talk about it in person with me, give a call to the office and we can set up a free consultation to do that, all right? But for purposes of today, I'm going to outline why we'd want to trust here. First off, what is long-term care? The way we describe things, trying to be as conceptually understandable, is long-term care is about 2 things. It's about our functional abilities and it's about our cognitive abilities, okay? So if we have an elder or senior in the family that's starting to decline physically, functionally, we're talking about the activities of daily living. Those are things we do every single day. You get out of bed, it's called transferring. You get out of a chair, it's transferring. But in the morning, get out of bed, walk to the bathroom, toilet, bathe, groom, dress, and eat. Those are the ADLs, the activities of daily living. And if you need help with them, we're in the world of long-term care. The issue becomes, how do you pay for it? So that's where trusts come in, okay? Instrumental ADLs, as I shared, that's more the cognitive. That's going to be driving, transportation, paying your bills, shopping for food, setting up your medications, housekeeping, okay? More of the processing, and we perhaps have loved ones that we know with short-term memory loss, or perhaps they're lost if they go out to drive. The dishes are piling up, the medications are piling up, the mail is piling up. That's somebody that is dealing with the decline cognitively, all right? And as I shared, it may be time for care. And if it's time for care, you can either pay for that care yourself out of pocket. It can get very expensive very fast. Or second option is some people have what's called long-term care insurance. Most people don't have that. But third and finally, most people end up looking at the Medicaid program. All right. And again, we're not getting into all the details of eligibility and benefits today. That's all on the website. But Medicaid is the government program that can pay for care in the house or care in a facility, assuming there's eligibility. Eligibility for Medicaid is about a person's assets, it's about a person's income, and it's about how much care they need, okay? It was never, shouldn't say that, it's grown. The care need issue, the need for advocacy has quadrupled, has multiplied tenfold over the last several years because Medicaid is focusing more and more on the care needs for people. Why? Because the asset eligibility and the income eligibility is attainable for a lot of folks. We spend a great portion of every day helping families shelter assets, shelter income, all within the bounds of the law. We do exactly what the law allows us to do to obtain Medicaid benefits for our clients. All right. Now, if we are looking at Medicaid benefits, what is often discussed, depending on which program we're talking about and depending on when we need that type of help, we'll be looking at something called an irrevocable trust. Okay. Ideally, you hit 65 years of age, you implement what we call an elder care protection plan. And I'll share that a little bit later, but that's the irrevocable trust. That's the start of asset protection. That is beginning to prepare for long-term care down the road, okay? So when we're talking with folks 65 and over, long-term care is a concern, and the irrevocable trust and our elder care protection plan is going to be a significant part of the solution, okay? So let's talk a little bit about the irrevocable trust. First and foremost, we have to be mindful in the world of Medicaid and protection planning of something called a look-back period. It's a period of time where we have to review everything, but of course the Medicaid agency reviews your assets. There is a 5-year look back for nursing home Medicaid benefits. And again, not getting into those crazy details right here, but if you plan and protect your assets in 2023, that protection is not fully effective until 28 in a nursing home scenario, okay? So protecting assets while younger and healthier is always strongly recommended. Now you'll see I also have the number 30 there with a question mark. Why is that, Brian? Well, because home care Medicaid will soon have a look back period as well. If you've been on these webinars for the last 3 years during the pandemic, New York State has been threatening us with a community Medicaid look back for nearly 3 years. They have finally made a formal announcement that the 30-month look back for home care will commence March of 2024. So we have another year of community-based Medicaid without a look back at all. Now's the time to get into that program if you need to, all right? I have a question mark there because they may postpone it again, but the Department of Health has said March of 24 is when it's going to come out. The beauty of protecting your assets when you're younger and healthier is you start that 5-year look back and you start that 30-month look back. That's what we need you to do. Protect some assets. You're not protecting everything. It's a balancing act. You have to protect some, but you need to keep access to some. You need to be able to live. You need to be comfortable. So you start the asset protection mindful of the look back. Next significant point is when we're talking about an irrevocable trust, the assets inside that trust can no longer be accessed by you setting up the trust, all right? The concept is hopefully understandable. When we put something into an irrevocable trust, what we're trying to do is remove it from our creditors. We're trying to remove it from Medicaid, from a nursing home, from New York State. And what we need to do is figuratively is we build a wall, okay, between the money in the trust, the house, for example, and you. We have to build that wall because if you have the ability to say, okay, trustee, I put $100,000 in my irrevocable trust, give me $20,000 back. If you had the ability to get that $20,000 back, then you have access. And if you have access, then so does the government. If you have access, then so does the nursing home or the car accident or the credit card company or the nursing home. So we have to modify that access, all right? We're not removing access entirely. What we're doing is preventing it from going to you directly or being used for your benefit directly. We always leave enough money outside of the trust for you to be comfortable with, and we build in a back door for children, okay? So there's always an ability to get money out of the children, get money out of the trust, forgive me. It just has to go to the children first, all right? Yes, if there's income in the trust, it can be distributed to you, not the principal, but yes, the income. You'd have the right to live in your house for the rest of your life. Your real estate tax exemptions remain. All right, you're not losing your veterans, you're not losing your citizens, senior citizens exemptions. You have the ability to sell with the help of the trustee, the ability to buy with the help of the trustee. Speaking of the trustee, you control the trustee. You can fire the trustee if you need to. So if you have your son as a trustee and you're like, listen, mom and I, we're out of New York, we're heading down to North Carolina, sell this home and buy that condo for us over on the Outer Banks. And if your trustee says no, you can fire them, all right, and get somebody that will help you fulfill your plans and your wishes. You can also change your beneficiaries. So if you've got 3 kids and God forbid there's a falling out, just because it's an irrevocable trust does not mean you're locked in to who you picked 10 years ago. You have the ability, as long as the trust is done right, you have the ability to change the beneficiaries. Significant, big flexibility right there, okay? We will often appoint somebody called a trust protector, again, to be discussed and explained, but it just adds another level of flexibility. You know, we see the word irrevocable too, and sometimes clients are like, I don't like that word. But as we detail all these points, there's a lot of flexibility and there's a lot of control retained by you, by the client. And this trust protector is one of those ways that we let you do that. Taxes such as income taxes remain the same, whether you have a trust or not. If you've got $500,000 in a mutual fund and you're being taxed on interest and dividends, you're still going to be taxed on that if you put it in the trust. Things remain the same tax-wise, okay? Revocation, remarkably, and I don't like to get this out there too much because I don't want people revoking these things, but if you need to revoke an irrevocable trust, there are ways to do it, okay? And last point on taxes, because I get this question a lot. If you sell the home, you're able to keep and use your $250,000 capital gains tax exemption, all right, without the trust and with the trust. In addition, children inherit the home with what's called a step up in the basis, all right, and the trust keeps that for the families. Significant issue on Long Island. You know, my parents have a trust just like this. That's not a surprise, I'm sure, but they bought their home in Malvern when I was 1 year old. For about $32,000. It's now worth what, $500,000-600,000, if not a little more. And when they, Lord willing, years and years from now pass on, me and my brothers will inherit that property at fair market value. The capital gains disappear. This trust, even though it says irrevocable, it's very transparent, all right, and a lot of control and a lot of flexibility. So if you hit 65 years of age, this is the type of trust you want to put into place. If you're over 65 without it, it's time to catch up a little bit, all right? Again, more questions about this, just put it in the chat box and I'll try to get to them later for sure. So why else do we need a trust? We've been talking about probate. Let me see the time. All right, we got more time. Probate is just introductory. Probate is the court proceeding that's required when somebody passes away with an asset in their name alone, okay? If there's a house in that person's name alone and they pass away, no survivor owner, then that house doesn't go anywhere until the court says so. Same thing with a bank account. Same thing with a life insurance policy where there's no beneficiary. It literally is in that person's name alone. And in order to get at it, we have to get the last will and testament and go through the probate courts. We want to avoid probate. And very simply, the ways that we avoid the court probate proceeding is by joint assets, beneficiaries named on our accounts, or trusts. No surprise there, all right? So why do we want to avoid probate? Why is it that big of a deal? If you can stay out of the courts in every aspect of your life, whether it's a traffic ticket, litigation, divorce, probate, surrogates court, you want to stay out of the courts. The courts are stressful. The courts are expensive. And what we're looking at here, did I go the wrong way? I'm going the wrong way here, guys. Sorry. Why do we want to avoid probate? Number one reason, time delays. All right. A probate proceeding is going to take at least 6 to 8 months, start to finish. Whereas if you had a joint donor or a trust or a beneficiary, heck of a lot faster. All right. Second reason to avoid the courts and to avoid probate, the costs, with the court filing fees, the legal fees, bond costs. Sometimes an executor has to post a bond, which is an insurance policy. Not every executor can get one. It's about credit rating. Legal fees can get up there depending on, are the siblings or the children, the beneficiaries, are they arguing, or is everything moving on smoothly? Okay. A major reason to avoid probate, to use a trust to avoid probate, is privacy. A probate proceeding is completely public. Everything filed on that probate proceeding, a probate petition, have the children's names, children's addresses, what they're inheriting. And in this day and age, why do you want that kind of information out there for the public to see? You don't. So joint accounts, beneficiary accounts, and trusts. That's what we do to avoid that. You could tell I wrote this during the pandemic. During the pandemic, if it happened once, it can happen again. The courts shut down for months. It then took them months to catch up. You don't want to deal with the courts, all right? Real brief, this is a significant major issue. Excuse me. If we have a single individual, no spouse, no kids, no parents, the court will make us find family. It's what we call due diligence. We have to locate the heirs. We have several estates right now, which we didn't do the planning for. We are looking for family in Ireland. We were looking for family. We've looked for family in Czechoslovakia. You have to hire companies, what was known as Czechoslovakia. You have to hire genealogy companies. We have to perform this due diligence to find heirs. You want to avoid that cost. You want to avoid those years of time. Contests. If you're disinheriting a child, or if you are giving different percentages to different people, you need to avoid the courts, because the court will require every child to sign off on that will before they allow it to go to probate. If you've disinherited your eldest child because you unfortunately haven't seen him or there's a terrible relationship, do you think that child's going to sign off on the will so the younger sister can get everything? No, there's going to be a contest. Years. You're talking years. You're talking $10, $20, $30, $40,000 in legal fees. You want to avoid that. Now, avoiding probate doesn't make that problem go away entirely. What it does do, though, is means you don't have to get the signature. Okay, so it allows things to move on without that requirement. If there's a probate proceeding and there's a disabled beneficiary or a minor beneficiary, court stops it, appoints what's called a guardian ad litem as an attorney to oversee what's happening to make sure that person gets what they're entitled to. It's another attorney. They're not working for free. So there's more fees, more delays, okay? Loss of control. A situation we see all the time. If we have a property in New York, we live in New York, but we have something in Florida. Not only are you doing a probate in New York, but you're also doing a probate in Florida. 2 probates. Everywhere you have real estate, you have to do a probate unless it's joint with survivorship or it's in a trust. Okay. So these reasons are speaking out for themselves as to why there should be trusts in place. An executor appointed by the court during a probate proceeding is personally responsible for debts. All right. Remember that when you pick the child you're closest to be your executor, if there are debts out there and they're not paid through the estate assets, there's a personal liability there. All right. If they're not paid through the estate assets, and they should have been, I should leave it at that. Another point, that whole long-term care world we were talking about before, Medicaid. If a person passes on after receiving Medicaid benefits, and there's an account in their name alone, and we have to go through the probate proceeding, New York State gets that money. It's what's called estate recovery. All right. Every beneficiary of the Medicaid program should have a bank account, and if so, it's got to have a joint owner on it. Okay, that way it doesn't go through probate, and that way New York State doesn't get it. All right. Last, final, and I call it a significant reason to avoid probate, is stress. Life is stressful enough. We have got one client who's an actual friend of the family right now. We did, in fact, prepare a will-based plan for this client. She refused to trust. I tried. Again, family friend. I wanted the easiest, best proceeding for her in the future. She passed untimely, very unfortunate, very dramatic, very too quickly, too early. The one child inheriting the assets and the other two not. We're in our third year, if not our fourth year, because those other siblings are fighting it. Talk about stress. All right, it's not something you want your kids to go through if you can avoid it. So you want to avoid probate. The number one tool we use to do that is what's called a revocable trust. Okay, that's why we talk about this. Now, a third issue as to why we would want a trust or need a trust, and I alluded to it before, is the whole concept of beneficiary issues. Do you have a beneficiary that's disabled? Do you have a beneficiary that is a minor or not old enough to inherit in your judgment? Do you have a beneficiary that has an addiction or perhaps incarcerated? Do you have a beneficiary that is a spendthrift or not very prudent or mature when it comes to their spending, or even a child with a rocky marriage? Those are all glaring trust reasons to have a trust in place, to have that inheritance held by a trust until these issues are resolved, or even perhaps for the balance of their lifetime. Okay, we've seen inheritances lost for each of these reasons. Okay, so be careful. With that, a word to the wise again is not every attorney does this in depth of a discussion with the family as to family and reasons and contingencies. You need a firm that specializes in this type of work. If you're on this webinar with me now, please realize, if you haven't already, this is the type of work that we do. If you haven't done your Tully Law plan yet, please work on getting that done. It will cover these contingencies. Fourth reason that you're going to want to trust, we're not going to get into this a lot. Again, there's another webinar on this on my website, estate taxes. And I felt it was very important to share this because we do meet with clients that are of a higher net worth. All right. And what we're talking about here is when somebody has, perhaps it's a business, perhaps it's another inheritance, real estate, there can be significant net worth there. And if there is a net worth over $6.58 million, New York State is going to be taxing that. Okay. And New York even has something called a cliff, where if you go 5% over this number, you lose all the protections on the first 6.5 million. So they're taking a graduated scale, they're taking up to 16% off the top. So if you have that kind of a net worth, include life insurance, include retirement accounts, include real estate in other states, other assets elsewhere. If you're there, and if you're married, there's different types of trusts we can do for married couples, or there's irrevocable estate tax trusts that we can do. Now, the federal government just doesn't sit around. They're sitting there with their hand out also, surprise, 12.9 million. Seems like a very, very high number, and it is. You need to have greater than $12.9 million for the federal government to hit you with estate taxes. Now, that's per person. The reason this is scary, two reasons. It's a 40% number over this threshold, and it's only until 2026. All right. January 1st of 26, this federal number drops down to the New York number. And New York, it'll go up a little bit more, inflation year after year. But again, if you're sitting there, I got 10 million, I'm fine with the federal government, you're not, because in 3 years, you're losing it. It's getting cut in half. And not to mention politics, right? Politicians are the ones that set these thresholds. These are very high. They were not this high a couple of years ago. So they can always be reduced again. If you have a several $1,000,000 estate, we need to talk about the benefit of different types of trusts so that we can minimize or eliminate estate taxes. Okay? Now, over the years, we've had some clients say, well, you know what? I know you're talking about a trust. Well, why don't I just give the asset to the kids? Why don't I just give that $500,000 account to the kids? Why don't I just give the house to the kids? They won't kick me out. Well, there's a slew of reasons, and I'm going to go through that list right now. I call it the D's. All right. So that's a D right there. And there's a little stretch here. You'll see it towards the end. But these are all legitimate reasons to not just give the house or the money to the kids. Can you make gifts to the kids annually? Of course. That's usually the part of a prudent plan, provided we have the assets to do so. But you don't want the house going to the kids. You don't want large, significant assets going to the kids outright. Why? Because they might die, or they might be ill, be diagnosed with a disease. There's your second D. They might go through a divorce. They might have drug issues that you don't know about. They might have financial or debt issues that you don't know about or may come later after they have your money. They may be dishonest that you're unaware of, or they might just do something dumb, okay? That wouldn't be the first time one of our kids did something like that. So we have to be prudent. The last D is the stretch. I called it a duty, right? If you travel, that's a tax. Taxes can be impacted. Capital gains taxes, real estate taxes, significant tax ramifications on certain assets if they're just given away. It has to be a part of a coordinated plan that we're helping you put together. Again, don't just, for safety reasons, for tax reasons, security reasons, don't just give significant sums of money or assets to the children, all right? Now, which trust do I need? And I see you're all still staying on here, so thank you. I usually like to finish up by 40 minutes, so I'm almost done. Which trust do I need? Well, it depends on your age. It depends on your health. It depends on the assets you have and where they are. Remember I said earlier, if you got a house in New York and a house down south, you got 2 probates to worry about, all right? And then beneficiary circumstances. So these 4 factors help us to determine which trust we recommend, all right? Glaring reason, hit 65, look at an elder care protection plan with an irrevocable trust. Disinheriting a child, real estate in other states, revocable trust, okay? Estate taxable situation, you're looking at something called a credit shelter trust. Disabled child, a supplemental needs trust perhaps. A minor, we're looking at a discretionary trust for children. Again, there's different ways we can go here, and I'm trying to share with you that there are answers to fit your circumstances, all right? So that elder care protection plan that I've mentioned, it would include the last will and testament, which we don't want to use. You need it, but we don't want to use it. A very comprehensive power of attorney. I can't stress this enough, but just we're running out of time. The everyday power of attorney you can get on LegalZoom doesn't work for estate planning purposes. It has to be modified. Healthcare proxy, living will, and yes, of course, the irrevocable trust. Now, revocable trust, what are we talking about? It's a probate avoidance estate plan. That's what the thrust of it is. It's going to have a unique kind of will called a pour-over will. Of course, it has that durable modified power of attorney, the healthcare proxy, the living will, and that revocable, and I even put in there living trust, okay? Now, whenever we do a trust for a family, every client receives or is a part of our client care program. It's included for the first year. Why? Because there's questions. This is new to you. So we have our client care program for the first year included. All calls, all questions, you're not getting billed. You want to make changes to the documents, you're not getting billed. It's a part of the first year of our client care program. We offer a funding meeting where you can sit down with one of our attorneys and say, all right, what do we put in the trust and how do we do it? We'll help you with that. An annual meeting. Let's sit down. Let's get the kids here. If you want the financial advisor, you want the accountant, great. Let's have an annual meeting 6-7 months out. How is everything operating? How's the communication? Are the trustees listening? Are the kids still involved? Any health issues? Do we need to make changes? It's important to check in. And last, remember I mentioned earlier our long-term care services. So we have advocates on staff. They've put together an assessment tool that deals with those activities of daily living and those instrumental activities of daily living, all right? You get this assessment tool at the end of the year. How am I doing? How's my wife doing with the walking, the bathing, the toileting? the driving, paying bills, etc. It's just a check-in. We want to avoid a crisis, okay? So we build in this client care program. It's optional after the first year. You can stay on with us. We've got clients for a couple of years at this point because they're taking advantage of it. They like having us on call, okay? Now I'm done. All right. Thank you for joining me. Again, very happy to answer questions. We've got a little more time. If I don't answer your question fully, or if you have a follow-up question, you can call the office and schedule a free consultation with me or one of my attorneys, one of my partners, or you can shoot me a direct email, Brian, B-R-I-A-N, at tullyeLderlaw.com, T-U-L-L-Y, elderlaw.com. And yes, you can find us on Facebook and Instagram as well. So I do see some questions here. Let's see if I can. All right. Okay. So question came out in the beginning, Steve, and we've addressed it, addressed the necessity of a trust in avoiding probate. So we've talked about that. What's the difference between a trustee and an executor? Good question, Linda. A trustee, as we've learned today, is the manager of a trust. An executor is the one that is appointed by the court to be the manager, if you will, of the will. Okay. So executor is under the last will and testament. Trustee is under the trust. Can you set up a trust if a person is in a nursing home currently? Is it too late to make a trust? I hate to give the lawyer answer there, Stacy, but it depends. All right. It depends on how much money is out there, and it depends on which type of trust we're talking about. There are times we come across clients who are privately paying for a nursing home. $18,000, $19,000, $20,000 a month, sometimes 15, depends on the facility. And they're just paying privately. You know, you could be $300,000 out of pocket before somebody tells you, or you bump into the reality of that we can protect money. If you're in that type of situation, Stacy, you may not need a trust. You just may need to establish a protection plan to get Medicaid to kick in eventually. All right. So if you have more questions about that, reach out and we'll talk about it more. Does an irrevocable trust need a separate EIN? We say yes. Okay. A very common irrevocable trust that we use is for elder care and asset protection in that world of Medicaid, like we spoke about. We will always do a separate tax ID number or social security number for an irrevocable trust. The purpose of that trust is to separate the assets from the grantor, from the creator. I don't want that social security number on that trust. I want as many differences between those two. All right. So we do a separate number. You're welcome. My folks have a revocable trust. They'd like to modify it now and don't want to go back to the original attorney. Can we handle it? Yes, of course we can. If you work with an attorney, you're not married to them, so to speak. You can then go to any attorney that you wish. And you don't necessarily need all the original documents from them either. You consult with us. If we need the originals, we can obtain them for you if they're needed at all. But yeah, we can certainly talk to you, Donnie. Thank you. I'd be honored to. Now, of course, if you're with us now, you're not allowed to go anywhere else. But gratefully, most of our clients don't move on. I had a financial advisor email me yesterday. Family gave him an irrevocable trust to look at because they want to move some investments around. And it says Medicaid trust on it. That Medicaid trust, written in 2012 by an attorney that I've now since concluded does not do this type of work regularly, allows the client to pull money out of that trust. As we've learned today, that type of trust does not work for asset protection purposes. That is a big mistake. That's an unfortunate reality that family went to a law firm that does not do this type of work regularly. If I had a nickel every time I saw a trust like that, or if I had a nickel every time I saw a power of attorney without the proper modifications in it, it's a shame that there are some families that have these documents trusting the firm and the attorney that they've gone to when the right documents are not being implemented. There's a lot of good colleagues that I have that have been practicing 10, 15, 20 years. Myself, 25 years I've been doing this. You want and need an experienced firm that focuses on these things. And the more help, the more support you can get with your planning, with your protection, with your care issues, the better. Why not? Take the help, it's out there. Oh, more questions. So if the property is passed in the will to a beneficiary, is a trust still required to avoid probate? So when a person sets up a plan, if there's a joint account with somebody, that goes to the joint donor when they die. If the person has a beneficiary on their life insurance, the beneficiary fills out the claim form, they get it. If they have their house in a trust, that trust will dictate where that house goes. If they have an account in their name alone, not joint, not trust, not beneficiary, then it goes through the will. So you don't have something going through a will and a trust, all right? It depends how it's owned and titled when the person passes away. How do you craft an irrevocable trust if you have different properties in different states? Nothing really changes. We'll do the New York deed to put that property in, and we'll do the other state's deed, or have a company or another lawyer that we work with to prepare that deed to get it into the trust as well. Where we see a difference in trust drafting, for example, is if there's a Florida property, because they have homestead exemptions for primary residences, which is a whole other conversation, but that's where we can tailor it based on the state. We got a lot of questions here. What are the tax ramifications when a vacation home in the trust is sold and the proceeds, all right, it's going to be the same thing, all right, assuming it's an irrevocable trust that we would do for asset protection purposes. These trusts are transparent when we're looking at taxation, all right? If it's a vacation home, it's not your primary residence. So whether you're selling it individually, or you're selling it through a revocable trust, or selling it through our irrevocable trust, that's being taxed. Capital gains are being taxed, okay, because it's not your primary residence. When would a revocable trust be better than an irrevocable? Good question, Phil. I'll put it this way. An irrevocable trust is appropriate if we're 65 and over and looking at long-term care asset protection, or under 65 with some health issues going on already. An irrevocable trust is also appropriate if we have significant wealth and we're looking for estate tax planning, okay? A revocable trust can always be used in those scenarios as well, but again, it doesn't provide asset protection. So it depends what we're after. If we're dealing with a 40-year-old couple, 50-year-old couple, 60-year-old couple, not yet ready for asset protection and not yet in need of estate tax planning, the revocable trust is the answer, okay? So hopefully that answers that. You're welcome, Diane. Thank you. That's the last question. All right, I've got a consult in 2 minutes. Thank you for joining us. Again, email questions, follow us on Facebook. We offer free consultations to help you and your family put this stuff together. So please reach out. Thank you, and be safe out there. Bye-bye.